Someone picks a fight with you. Maybe there's a misunderstanding or even a false accusation. One wrong move and suddenly you're facing a felony assault charge under California law with possible prison time. But what if I told you there are 3 powerful defenses that can get your charges dropped or reduced? Defenses that prosecutors don't want you to know about. I'm Dan Colasia. I'm a criminal defense attorney, former prosecutor that has seen thousands of assault cases in California. And in this video, I'm breaking down the 3 best defenses to beat your felony assault charge in California because your future depends on it. Before we break down the defense, we must first understand what is felony assault under California law. Felony assault is a crime under Penal Code 245A4. So what exactly does Penal Code 245A4 say? Felony assault is an assault on another person with force likely to cause great bodily injury. This can involve any means of force. It's not just about hitting someone with a fist. Anything that could cause serious harm qualifies. Think of things like using an object as a weapon, pushing another person with your hands and they get hurt, or even hitting them with something like a bottle or a chair. You can even have felony assault even if you did not touch someone. The code makes it a crime to do an act where it is likely that force can cause great bodily injury. When I was a prosecutor, I had a case where assault was charged when a guy threw a beer bottle at another person. The beer bottle was thrown at the person, but thankfully, the bottle missed him. That guy was still charged with assault because the bottle, even though no one was touched, could have hit the person in the head. To put it simply, this charge is about assault that goes beyond a typical fight. It involves force that could cause severe injury, but doesn't necessarily have to. The key here is that the potential for great bodily injury must be present. So what does the prosecution must prove? Let's talk about what the prosecution needs to prove to convict a person of this charge. To secure a conviction under Penal Code 245A4, the prosecutor must prove 4 main elements beyond a reasonable doubt. First, the prosecution needs to prove that a defendant did an act likely to touch someone that, if touched, that person would produce great bodily injury. The act done would only mean to touch that person in a harmful or offensive manner, causing great bodily injury. The prosecution does not have to prove you intended to break the law, hurt someone. The prosecution does not have to prove you touched someone. The prosecution only needs to prove beyond a reasonable doubt that if you completed the act, like the punch, the person would have suffered serious injury. Second, the prosecution needs to prove that the defendant did the act willingly. That means the act was not done by accident, it was done willingly or on purpose. Third, when the person acted, the act would likely result in touching another person. For instance, the person tried to punch another person in a bar fight, even though they threw the punch and missed. When he was acting, he was close enough to punch that person, versus someone throwing air punches 50 yards away with no one around. Last, when the person acted, he had the ability to apply force that would likely produce great bodily injury. Basically, they were close enough to cause the injury. What does likely to cause great bodily injury mean? Great bodily injury means a serious or significant injury. The general rule of thumb would mean great bodily injury is an injury that requires stitches or more to heal up. So we're talking about serious cuts, broken or fractured bones, or more. Well, a simple push where no one was hurt would not be great bodily injury. But if you push someone, they fell on the ground and broke a bone, that might be enough. That could produce great bodily injury. A forceful punch to the face or using a weapon and it hurts a person could cause great bodily injury. Great bodily injury isn't about a bruise or a small cut. It means significant injury like broken bones, concussion, or even worse. Let's talk about the penalties for felony assault under Penal Code 245A4. This is a serious charge that can result in some heavy penalties if you're convicted. If convicted, the punishment could be up to 4 years in state prison. Yes, I said it, 4 years behind bars. If there are any aggravating factors like prior convictions or using a deadly weapon, that sentence can go up even higher. And the judge has discretion to also impose fines and mandatory anger management or violence prevention programs. That 4-year sentence can be even higher if there was great bodily injury that occurred or a deadly weapon used. You can see from 7 or 10 years or higher with these factors. While this charge is a felony, it's important to note that under California's felony sentencing laws allow for some reduction in penalties depending on the circumstances of the case. You may even have probation if a skilled defense lawyer can argue that, or a lawyer can reduce this charge to a misdemeanor. That's why it's crucial to have an experienced attorney, someone who can navigate the nuances of these laws to help reduce the consequences. So what are the top 3 defenses you can use that are incredibly effective? First, self-defense. This is probably the most common defense in these type of cases. If you can show that you are acting to protect yourself or someone else from imminent harm, self-defense can be a powerful defense. Remember, the key here is that the force used must be reasonable, not excessive. Let's break down the self-defense argument. Self-defense requires 3 things to be effective. First, the defendant reasonably believed that he or someone else was in imminent danger of suffering bodily injury. Remember, the danger must be imminent. That means happening right now. Belief in future harm is not enough. This imminent harm belief must be reasonable, and then they acted on this reasonable belief. The jury will determine what is reasonable and consider circumstances known to the defendant at the time. Number 2, the defendant reasonably believed that the immediate use of force was necessary to defend from danger. Again, the reasonable belief, this will be determined by the jury. The jury may get to consider prior threats of harm or prior harm toward the person in the past. Number 3, the defendant used no more force than reasonably necessary to defend again. The reasonable belief here that they had to use self-defense and use a reasonable force. Reasonable force means you cannot shoot someone if you're in the middle of a bar fight with no weapons, or when pushing the person out of the way was a better solution. So California law allows self-defense. It is a powerful defense because once it is established, the burden shifts to the prosecution to prove beyond a reasonable doubt this assault was not self-defense. The second defense for felony assault is the touching was accidental, or what we call accidental harm. If the prosecutor can't prove that you intended to harm the victim, you may be able to argue that the assault was accidental or a result of a misunderstanding. For example, let's say you're in a crowded place and you accidentally tripped another person and they fell to the ground and they broke a bone. This would be accidental versus if you intentionally stuck your foot out and tripped the person, causing that broken bone. Your best argument here on the first argument is that you did not intend to seriously harm the other person or even do the act. Like all defenses, you will need to convince the judge or the jury that you acted accidentally. And third, false accusations. Unfortunately, people sometimes get into trouble and make false accusations out of revenge, jealousy, or to avoid the consequences themselves. In my years as a prosecutor and criminal defense attorney, I have seen false allegations of assault happen. Look at it this way. Law enforcement will go to a scene of an assault. Police officers will interview the reporting party, and they are claiming they were attacked, and the police will interview them for about 10 to 15 minutes. Maybe do a short search for witnesses, take a couple of photos, and arrest the person, the witness accused. For false accusations, you need an experienced attorney to do an investigation of the case, find additional witnesses, maybe look for other evidence of what really happened. If you find yourself a victim of false allegations, the best bet is to remain silent if the police ask you questions, because you're not going to be able to talk your way out of the arrest. Then document what occurred, document location, document potential witnesses, and give this information to your attorney. You build a case of what really happened, in that the accusation is fabricated. and you can completely discredit the person in the charge, which can lead to a dismissal. Now, if you're facing a felony assault charge in California, the most important factor in winning your case is talking to an aggressive criminal defense attorney that will take action on everything you learned today. Don't hesitate to reach out to us at Colossia Law. And if you have any questions, just give us a call. We just covered how to beat a felony assault charge in California. But what if cops are claiming you committed assault and you didn't even touch the other person? Is that legal? Well, check out this next video where I break down what you need to know. See you over there.